Okay, all right, so here we go. So welcome again, everyone. Thank you for joining us for a training on working with clients with criminal histories. Your presenters today are myself, Bila Lindner, and my colleague, Lily Harvey. And we are from Homebase, which, if you're not familiar with us, we're a nonprofit organization that provides technical assistance and training to housing and homeless service providers in San Mateo County. And just a heads up that we are going to be talking about legal issues today and restating guidance from various government agencies. But the content of this training is for informational purposes only. What we're talking about today does not constitute legal advice. So if you have legal questions or concerns, we recommend that you reach out to your agency's legal counsel or HSA for further guidance as needed. So now I'm going to briefly see if Lodi has anything that she would like to say by way of introduction. It looks like she's here today as well.
Yes. Hi, everyone. Hopefully you can hear me okay. Just before we get started, just wanted to say thanks so much for joining us, and thanks to Homebase for hosting the training for us today. I know it's such a important and complex topic. So glad that we have this space to kind of gather and learn more and ask questions here. So yeah, without further ado, I'll pass it back to Violet to get us started.
Great. Thank you. So just an additional heads up for those of you who might be interested, we wanted to let you all know that within the last year or so, Homebase created the Criminal Legal System Initiative, which provides sort of specialized technical assistance and training on issues at the intersection of homelessness, housing instability, and the criminal legal system. So it's sort of a specialized TA provider within Homebase as a whole. And the initiative was born sort of in response to the fact that a lot of the communities that we work with have been sort of struggling to figure out how to meet the housing needs of people who have criminal legal system involvement because of some of the unique barriers to accessing housing that we're going to be talking about and thinking about today. So the initiative, was really born out of that and trying to figure out ways that we can, increase capacity and provide assistance to help people, help people in different communities address the housing needs of people involved with the criminal legal system, and also with an understanding that access to housing is part of achieving true public safety. You cannot have true public safety, when large groups of people, particularly people involved in the criminal legal system, do not have access to safe, adequate housing. So that's really what drives the Criminal Legal System Initiative. Just a couple of things that we offer here noted, that we offer targeted workshops. We help facilitate cross-sector partnerships between public safety side folks and housing side folks, as well as other partners. We develop curated tools and resources, and we can also offer opportunities for peer-to-peer learning and community building. So what we're going to do is we're going to drop a link at the end of the training to the mailing list that we set up. So we encourage everyone to sign up for that mailing list that will provide sort of information every now and then about addressing the housing needs of people with criminal legal system involvement, as well as some of the tools that we've created to help people people do this important work. So without further ado, I guess we can get onto our goals slide now. Thank you. So we have 4 goals for today's training. And the first one is for everyone here to understand the intersectional nature of housing, homelessness, race, and the criminal legal system. Also to identify what criminal histories can and can't tell you about your clients. To learn ways to recognize and minimize barriers to housing for clients with past convictions. And also to explore specific considerations for people on the 290 or sex offense registry. So we're going to start by answering the question, why talk about criminal histories? Then we're going to talk about some of the limitations on how we can and can't use criminal history information making decisions around whether or not to house someone or offer them housing assistance. Then we're going to shift focus to special considerations for working with people on the 290 sex offense registry. And then we're going to round it out with some practical considerations and tips and have some time for Q&A as well. So why talk about criminal histories? I'm sure a lot of you have your own thoughts about this, and that's why you're here today. But the three major reasons that we are thinking of right now are, number one, criminal histories and thinking about them and talking about them in the right way matters when we consider broader equity issues. They also can create barriers to finding and sustaining stable housing, as I'm sure a lot of you have experienced in your work. And also understanding criminal history backgrounds can help us serve our clients better. Focusing on reason number one for a moment. So criminal histories matter when we consider equity issues. This is because we know from data and lots of research and just tons and tons of evidence that certain groups are disproportionately incarcerated and experience homelessness. And this is true at the national, state, and local level. Next slide, please. So when we're talking about equity or inequities at the national level, we know that people who have been incarcerated are nearly 10 times more likely to experience homelessness than the general population. That means that being incarcerated is a major risk factor for experiencing homelessness and housing instability. There's a direct link there, and that's unfair. We also know that Black, Indigenous, and other people of color and LGBTQ+ individuals are also disproportionately represented in both the homelessness and criminal legal systems, right? So disproportionality means that, you know, these people are overrepresented in relation to the proportion of that they make up in the general population. And that's something that, you know, is obviously we're all thinking about and trying to address in our communities. So that is some of the national data. The next slide also speaks to national data a little bit more. We know that Black adults make up 12% of the US population, but they make up 33% of the US prison population and 43% of adults experiencing homelessness in the United States. We also know that LGBTQ individuals make up 4.5% of the US population, but they are 3 times more likely to be incarcerated. And one study indicated that LGBTQ youth experience homelessness or housing instability at over double the rate of the general population. So really just, you know, keeping these figures in the back of your mind as you think about why does it matter that we talk about and think about criminal histories when we make housing determinations. Why do we need to get this right? Because of the disproportionate impacts on these particular populations that then prevents them from securing housing and you know, enjoying their lives. So moving on to the next slide, which is the California context. So looking at California specific data. So Black Californians make up 6% of the state population, but they comprise 29% of the people experiencing homelessness in the state. And Black Californians are also incarcerated at almost 7 times the rate of white people and 2 times the rate of Latinx people. So now we're going to talk a little bit about what's happening at home in San Mateo County. I'm going to pass it off to my colleague, Lily.
Hi, everyone. So just to talk a little bit about San Mateo, one thing, a little disclaimer on this information, the 2017 data is not super recent. I apologize for that. BSCC is an agency, a statewide agency that gathers this kind of data, and that's the most recent data they have. So in my effort to try to apples to apples as much as possible, I had to go a little dated, but you'll still get the general gist of the idea. So wanted to start here with this 2017 population estimate in San Mateo by race and ethnicity. won't recite the whole slide to you, but just to flag some of the AINA is Native American and Alaskan natives. I think I mixed up those, sorry. And then NH is Native Hawaiian and PI is Pacific Islander. So you can see, majority of the population identifies as white. Hispanic, any race. The fact that race and ethnicity data is being combined makes it a little bit tricky in a second, especially to compare the data, but get a sense of a fairly small population identified as Black, pretty big Asian population relative to the rest, and then multiracial smaller group, as well as the Pacific Islander Native Hawaiian. Next slide, please. So then this is just to tease that out, same year, same source, so the 2017 homelessness by race and 2017 arrest by race data. So that just here trying to highlight a little bit some of those disparities that Viola was just naming at the national level are reflected in California, and then are also reflected to some extent here locally. So it gets kind of hard to, you'll have these slides later if you want to look at them and all of the references. There's a reference slide for you too, if you want to see the data sources more closely. But wanted to particularly highlight here the distinction between the, particularly for people identified as Black. So it's 2.5, but it was rounded up to 3% for the general population in San Mateo in 2017, but comprising 13% of the homeless population and 17% of the arrest population. So it's really significant disproportionality there. And you can see some of that reflected in other groups as well, although because the numbers are smaller, it doesn't seem as striking, but it is actually still, the difference between being 0.02% of the general population and 2% of the homeless population is actually a really big difference, even though it doesn't quite feel like it when you're looking at it. And of course, then limited here by the arrest data, not capturing some of the more nuanced racial and ethnic group breakdowns. So you can still kind of get a sense for it. And then the next slide, I just wanted to share here. This is information that was pulled from HMIS that similarly just kind of highlights the disproportionate impact that these systems have on certain groups. Again, highlighting particularly the experience for people identified as Black, who again, 3% of the population, 70% of the arrest population, and here 23% of known releases from jail into homelessness. So again, you see the same people are being disproportionately impacted throughout, moving through all of these different systems. And so just wanted to add a little bit of local context into the conversation as we're thinking about the national issue, the state issue, and then how it comes to bear here in San Mateo. All right, so then moving on to our second why to talk about criminal histories point. So probably why you're all here, they create barriers to finding and sustaining stable housing. So go ahead and go to the next slide, please. You often hear people use the phrase collateral consequences or long-term consequences of convictions. Collateral consequences just refers to consequences that continue to follow someone after they've been released from jail or released from prison that are baked into our laws and regulations. So that are sort of sanctioned ways that people are still limited, curtailed in their freedoms, discriminated against, and it's a formal way of doing it. There are also long-term consequences that are not collateral consequences because they're not part of the laws and regulations, but they have really long-term impacts. And that can be just sort of stigmas associated, sort of individual discriminatory things that aren't necessarily legal, but it's not something someone's probably going to go, press charges because someone is being discriminatory in that way. And that certainly plays a role in housing because there are ways that these collateral or long-term consequences directly address housing. And then there are all of the ways where it's one step removed, right? So whether the collateral consequences are things like limitations on the kinds of businesses you can own or licenses you can obtain or jobs you can get or the right to vote, things like that may not directly impact housing, but they may actually have a very large, particularly employment-related stuff, right? And, in California, in the whole country, in California and in San Mateo, bonus especially, having a living wage looks really, really different. I mean, it's incredibly hard for probably many of the people on this call to find stable and affordable housing in the community. So anything that is creating those additional barriers, whether it's directly related to housing or not, can have a really big impact. Next slide, please. So just to kind of drive the point home, just as an example, again, I'm sure you're familiar with this, but some of the collateral consequences that directly impact housing have to do with things like, for example, HUD's rule about the Public Housing Authority mandatory screenings for people who've been convicted of methamphetamine production in federally funded housing, or people who are lifetime registrants on the sex offense registry. So that's just a straight correlation. You've been convicted of something, and therefore you are permanently banned from housing. And so those kinds of collateral consequences come up in different spaces. The long-term consequences come up certainly, and we'll be talking about a lot of those today. So I wanted to take a quick pause. We are going to be asking you all to chime in on chat and to do some polls and to come off mute if you're so moved. So just to warm up everybody's, I had decaf today. I don't know what I was thinking, so I hope you didn't. You can buoy me through this. We wanted to start by asking you all, I think it's such a great chance to share and learn from each other. What kinds of barriers do your clients who've been impacted by the criminal legal system experience? So feel free to hop in the chat and type stuff, or feel free to come off mute if that feels easier. But what are the specific places where people's criminal histories are coming up and are making it challenging for people to access and then maintain housing?
Lily, so with working with clients on the first step of attempting to retain income, employment is such a big issue. So it's almost a domino effect. Well, it is a domino effect. Like if you don't have any income, you can't get any housing. And then if you do have felonies, you're limited to low income housing and also getting like government assistance.
Right. That domino effect is huge, right? It's like, it may not be the obvious housing like consequence, but it's all the ones that lead up to it that equal you're getting screened out or barred from housing. I think that's a really good point. Is that what everyone else is seeing too? Are there any places where it seems like certain kinds of things, certain kinds of barriers are really coming up for folks? That's it. Everyone had decaf? We're in trouble. Yeah, thank you, Victoria. Friends and family don't want to help them. That can be right. Britt, you can burn a lot of bridges, especially for folks, I think, who are gone for long periods of time or who are cycling a lot. I don't know if probably some of you were at our custodial trauma training last year. And one of our presenters, Victoria, talked about that, just having been in and out. She couldn't even remember which counties she'd been in and out of jail with, and just the experience of trying to figure out how to come back to her family and how to have everyone believe that it wasn't going to happen again. That can be really hard, and especially in a place like San Mateo, where staying with friends and families can be the easiest option and the most stable option, unless it's not an option. So thanks for sharing that, Victoria. What are other places where either the laws and regulation barriers make it really hard for people to access housing, or like Victoria's raising, it's not a regulated thing, but it can be a very real long-term consequence of incarceration?
The type of clients that I see are kind of more 290 that kind of have the issue with shelter. It gets limited to the resources, and then it kind of, again, domino effect, can get shelter, then they can't get work. And if they can't get work, they can't get housed.
Right. That cycle, right? It's like you need one of the things to change. Yeah. And folks on the registry, it's huge. That's why we're going to spend a chunk of today talking about that. And I'm seeing, also, Miguel, thank you for that. Lack of support when released to a county they are not from. Right. You don't get to pick where you're released to. It's often where you are convicted. Sometimes you can petition to be moved elsewhere. Sometimes decisions will be made, but a lot of times people are paroled to communities where they don't even have the supports that might exist if they were where they were, from, or where they had family. And I think it's tricky to move there. So yeah, it's a really good global point. All right, well, feel free to keep any other thoughts coming in. We'll go ahead and move on. But I think that, you all just did a great way of sort of briefly summarizing some of the like baked in collateral consequences of like, you're not allowed because of XY conviction to do something that impacts housing. And then again, these softer realities around support systems and support networks that people have to lean on so much of the time. And if they're not there, it gets really hard. So thanks for that. So one more piece on collateral consequences. before we move to our third good reason to talk about this stuff. Just has to do with scope. And this is national information again, but it's just to kind of flag, I'm making some assumptions about folks who are here today probably know that they are working with people in reentry, maybe people who've experienced reentering the community from incarceration yourselves. So you have a good sense of a lot of this, but as I suspect you probably know, the scope of who is impacted by the criminal legal system is massive in our country and certainly in our state, right? So every year, an average of over 600,000 people enter prison. So just enter, not are incarcerated, but just are coming into prison. And 10.6 million people enter jail. So that's alone just a ton of people, right? And all of their families and all of the places where they had jobs and all of their cars that are impounded and all of their everythings, right? There's just like a lot that goes into each of those individual lives that are directly impacted. And then the collateral consequences and the long-term effects piece of this is that 74% of people who are held in jails aren't convicted of any crime, right? So there are people who are cited and released. There are people who charges are dropped or are never filed. There are people who are, awaiting trial, go to trial and are found not guilty. But 74%, so significant majority of the people in our nation's jails aren't convicted of any crime. And yet they may still have, maybe not the laws and regulations, collateral consequences, but those long-term effects of even things that they aren't found guilty for, right? They're supposed to be viewed and treated just the same by all the laws and everything as someone who hasn't been in custody, but they aren't. And I'll just give one illustration. We did a training in San Diego not long ago, and our presenter was telling a story. He's a veteran. He had, house and kids and car and family, struggled with addiction and mental illness, lost everything, was sleeping in his car, parked his car in a really nice neighborhood because it felt safer. Police officer knocked on the door. He was arrested. No charges were filed. He was released 2 days later, but he lost his car, and that's where he'd been sleeping. He didn't have the money to get it back. And so, started off, 10-year on the streets, real spiral into behavioral health issues. And so even though he was part of the 74% of people who were held in jails, nothing happened. He hadn't done anything legally wrong. He still had to deal with these long-term, really significant long-term destabilizing consequences of even having that touch with the system. The last point on this slide is just having to do with technical violations. I'm sure some of you were at the training we did last year where we talked about sort of legal system lingo or know these terms anyway, but technical violations briefly for people who get out of jail and prison, they're often on parole or probation, which is also referred to as community supervision. And they have extra rules they have to follow that aren't the rules of the prisons and jails, but they aren't the same rules as people who aren't on community supervision. So they have to do things like, you have to do tests, drug and alcohol related screens and tests. You have to report changes of address within a certain number of hours or days, depending on your conviction, those kinds of things. But they aren't crimes. But the majority of people in California actually, and it's here, technical violations are the main reason for incarceration of people on parole or probation. The reincarceration of those people is if you make a mistake and you, for example, don't tell your parole officer that you've moved in a certain amount of time, you can be sent back to jail or prison. And that is a real driver of who's in our jails are people who have not committed a new act that is a criminalized act that they've been convicted of, but someone who's run afoul of one of those community supervision requirements. So this is all just to, again, drive the point home that that so many people are being impacted by these rules and by these long-term consequences of even just exposure to the criminal legal system on any given day. All right. So why talk about criminal histories? Reason number 3, understanding them can help serve clients better. Definitely really important. So real quick, wanted to do a poll. Go ahead and pull up the next slide. So this is for you all to ask. And can someone launch the poll? Sorry, I have my Zoom all hidden. Yes, maybe. Viola or Joy, can one of you launch it? Yeah, thank you. So feel free to use the chat. This is, you can't do multiple choices here, but share. This is, I think, a good way to learn from each other too. How does your organization or agency use criminal history information? Are you using it primarily for eligibility screening, to make housing placement determinations, to know how to refer people in the community to certain services, to build out case management plans, something else? especially if you're writing other, please feel free to use the chat. Or if you have no idea, you suspect that you use it or you're not sure if you all use it. So I'll give it just a minute. Feel free to put any clarification, or if you do all of the above, I didn't put that option. Or feel free to come off mute too, if that's easier. Give it just 5 more seconds, maybe, if you want to chime in. All right, great. And hopefully we can share those results. So really interesting, a good screen. Are the results shared? I hit they were, hopefully so. I suffer from small screen presentation syndrome, which is where something is always hidden by something else. So it looks like a lot of you all the majority use criminal history information for eligibility screening. So we'll talk about that in a little more detail in a bit. Definitely in determining housing placements. So for people in your programs, sorting through that. Oh, sorry, Miguel, you're right. I can't hear you, but I want to hear you. Yes, please keep trying. Feel free to direct chat, maybe Joy or Bila, and they can try to help troubleshoot, or feel free to use the chat if that's just as easy. Sorry about that. And it also looks like people use the criminal history information for community resource referrals, case management plans, a fair amount. So really an interesting spread, and I think good to know, kind of get a sense of how the community is using that information. So thanks for that. So all of these reasons, and we'll talk about them in different pieces throughout the training today, but all of these reasons, the eligibility screening, housing placements, referring people to different places, these are all ways that are super common uses of criminal history information, or CHI, CHI, and I might start saying that because it's a lot of words otherwise. But some of them actually have like pretty significant limitations and restrictions that are not commonly known about or enforced. And we'll talk about some of those today. And some of them have very real sort of global benefits, where some of them can be a little bit more detrimental, particularly in light of the demographic information and the disproportionate impact information around equity that Bila was covering earlier. So before we switch over to the next section, just a couple slides kind of by way of summary on what we can and can't learn by looking at client criminal history. So we'll start with the can'ts. So the first one on here is the final outcome. Now, this is a little bit of a wonky bullet point. So what I mean by that is, depending on where you get the criminal history information. So lots of people will look at rap sheets.
Hello.
Oh, hello. We can hear you. Is this Miguel? Were you trying to say something now? Not to call you out if you don't feel like talking anymore. Okay, let us know. So the final outcome. So as Bila will talk about in more detail coming up in the next section, there are pretty significant limitations on what kind of criminal history information you can use when you're making housing determinations around eligibility, around placement, any of that stuff. And so it's really important in light of that to know what's called the final disposition of something that happens. So rap sheets, for example, will have a lot of information about arrests, about charges, and sometimes, especially if you're not used to reading rap sheets, it's really hard to tell what the final outcome is, the final disposition. So if this is something that your agency encounters trying to figure out a lot, feel free to reach out via email. We'll have our emails at the end. We do have a little guide that's pretty helpful on how to read rap sheets. But yeah, I mean, it's a huge thing. And this is not everybody studied law enforcement or like went to law school and is trying to figure these things out. So that can be really challenging. It's also challenging to figure out the final outcome, particularly if you are having information pulled from a company or something like that that's looking across multiple sources, because often it is the case that there are errors, and you definitely don't want to be using information that reflects an erroneous conviction or something that was, appealed, and then the person, it was turned over on appeal or something like that. And be having someone experience discrimination based on something that shouldn't be considered at all. So it is really important to try to figure out if you can determine the final outcome, if you're planning, or someone is, telling your client, you can't live here because of, this conviction I'm seeing on your record, to make sure you're verifying that those are accurate and that those are things that you're permissibly allowed by law to consider. Another thing that we can't learn by looking at criminal histories, and the next three kind of go together, is whether our clients are dangerous to themselves, to other clients, or to staff. And this is like a pretty hard pill to swallow in a lot of ways, right? You know, if you look at someone's record and they've got 25 even arrests for aggravated assault, it's hard to not go, well, yeah, that sounds like it might be a thing. But the truth is, for all the reasons that Violet articulated earlier, and all the reasons that we know about how, you know, a printout that has a conviction doesn't tell a full story. You know, it doesn't tell a story of trauma. It doesn't tell a story of context. It doesn't tell the story of, you know, abuses that were happening that someone was responding to, or addiction that was unmet and has been addressed now, or of, you know, mental illness that someone is receiving help for now that they weren't previously. None of that is on a printout of someone's criminal history. Right. And so the very real and important desire to keep yourself safe, to keep your colleagues safe, to keep your clients safe, other vulnerable people safe, very, very important. But pumping the brakes and pushing back personally, organizationally, and as a system about the assumptions that are made, especially when we know there's systemic and personal contexts that are not always visible, right? There are tons and tons of people who cause serious harm in this world who are never arrested for it, right? And they get housing all the time. So just trying to challenge ourselves to look at that and to really remember what is being baked into these convictions beyond just what you can see on a printout. Related to that, trustworthiness, right? I think that comes up a lot. I know I'm an attorney, and for the bar exam, you have to do this sort of moral deservedness thing, and you have to get letters from people, and they comb your entire history, and it's really weird. And one of the things is like looking at whether you're trustworthy. And I remember I had a friend who forged a check as a teenager, and it was this huge thing, and she had to like go through these hearings, right, on it. And the truth is, for things like check forgery, which is considered a crime of you know, deception and untrustworthiness, it's really like almost all of the time a crime of survival. Someone's forging a check not because they have $1 billion in their bank account. Sometimes that happens, but it's not super common, right? So is that about trustworthiness, or is that about access to resources? So I think, again, the assumptions that we sort of collectively hold as a society that are baked into our laws and regulations that are reflected unintentionally in our policies and procedures are really, you know, it's important to take a second look at them to see if we are making assumptions about what we can and can't rightly assume. And then the last one is deservedness, right? Like in a landscape where housing scarcity means that not everybody gets housing, and we have to have systems like coordinated entry that look at vulnerability and prioritize people, it gets really complicated, and it's very imperfect, as everybody knows, right, about who is so vulnerable that they deserve housing, when that really shouldn't, like, no one wants that to be the conversation. Everyone deserves housing, right? But particularly people who have criminal backgrounds, people get bumped way down on that moral deservedness ladder. Again, based on these things that we know can be flawed in a ton of different ways. So just putting those plugs out there, and hopefully we can have more discussion about this later in the ways that, you know, on the one hand, we can know these things, and on the other hand, there can still be some very real world applications of these hierarchies that have to happen because of resources, because of a need to keep yourself and other people safe. They can kind of start flaring up. And so finding ways to sort of check in and make sure things are not creeping in ways that are actually detrimental to the overall cause of trying to help people have access to the stabilizing force that is housing. All right, and then last slide before I turn it over to Viola for a little bit. What can we learn by looking at criminal histories? So this is really important for those of you who said that you incorporate this kind of approach in how you use criminal history information. Definitely encourage those of you who don't usually use the information in this way, but are gathering that information to consider using it for these purposes. One, ability to target services. We'll talk about this a lot more in the sort of tips and tricks portion of the training for people who, you know, there are expungement services or record clearance options. People can apply to be retiered on the sex offense registry. There are all kinds of things that people can do. There are reentry service providers. The community piece for people who are coming out of carceral settings is huge. Feeling like you're feeling like you're alone and that no one can understand your experience is a very, very real thing for a lot of people, generally in the world, but a lot, something you hear a lot if you work with people impacted by incarceration. And so try to help connect services, community, others who will understand and help guide people through decreasing those barriers is really important. Of course, trauma-informed approaches, specifically around custodial trauma. Hopefully some of you came to that training that we did last year on that topic. Is a piece of understanding the whole client, is a piece of building rapport, really having that rapport be such that clients feel comfortable telling you all of the things that they are struggling with and all of the reasons a housing option might not feel safe or might not work or might not be a good idea because of community supervision requirements, things like that can be a massive piece of really being able to do effective trauma-informed, motivational, client-centered case management. And the last piece too, a little bit more nitty-gritty is, as I just kind of alluded to, the ability to make sure that housing options and supports that you are finding and helping your client access are aligned with any community supervision requirements. If you can't live in a certain neighborhood, or you can't live with a certain family member, or in a space where the family member might be coming, or you're not allowed to associate with certain people, or live in certain proximities to a daycare or a place where children are located, things like that. It's all really valuable and important information for people who are helping look for housing options, because otherwise you could be spending your time and precious resources finding something that won't be a good fit. And usually people know about their restrictions, but not all the time. And sometimes people are uncomfortable saying that something won't work too. So just a really important one there too. All right, so now I will go ahead and turn it back over to Byla.
All right. So now we are going to talk about some of the legal limitations on considering criminal history information when making decisions about providing housing and housing assistance to someone. Next slide, please. So in California, we have an agency that investigates and enforces California's civil rights laws, including those listed here, and that is the California Department of Fair Employment and Housing. Next slide, please. And in California, the civil rights and housing laws apply to all of the different types of housing listed here. So I'm not going to go through all of the different types of housing listed, but you will see that it applies to private housing, for example, single family homes, multifamily homes and apartments sort of on the private market, as well as programs that people might be running, such as transitional housing programs, supportive housing programs, residential hotels and motels, and shelters. So in other words, they apply to your programs, and they also apply to the landlords and the property managers that you might be working with in order to permanently house your clients. So what this means is that you need to be aware of them, both in terms of making sure that you are complying and that you are not excluding folks from your programs unlawfully, as well as making sure that your clients aren't being discriminated against when they go out and apply for housing with a landlord, so that you can make sure that their rights are protected as well. So the purpose of this knowledge is really twofold. Okay, next slide, please. And for our purposes today, I'm going to focus on the Fair Employment and Housing Act, or FEHA. And we did a joint training last year with the Department of Fair Employment and Housing on FEHA, which can be found on YouTube. So I'm not going super in depth into FEHA regulations right now, but just sort of providing an overview in the context of the broader discussion we're having today. So a little bit about FEHA. FEHA protects people from housing discrimination based on certain protected characteristics, such as race, color, national origin, religion, disability, gender identity, familial status, veteran status, sexual orientation, and source of income. What is a little bit tricky about FEHA is that having a criminal history is not a protected characteristic, but New regulations that went into effect in January 2020 essentially made it unlawful for people to make decisions about offering housing, housing someone, allowing someone into a housing assistance program, to make those decisions based on criminal history information without having a legitimate justification for doing so, and without giving the person who you're denying access to the opportunity to sort of provide what we call mitigating information, right? To say, this happened a really long time ago, or this happened, when I was having a manic episode, and I've since, been receiving treatment, and it's related to my disability, that kind of thing. That's what we call mitigating information that helps kind of explain what happened, and provides that broader context that we've been talking about with regard to who people are who have criminal legal system involvement. They're not just their criminal convictions. So, and again, the reason, underlying FEHA and this criminal history related requirement is that, criminal history information, when you take it into account in making these decisions, that can have a disproportionate impact on people of color and LGBTQ plus persons and other folks who we've been talking about, who are overrepresented in the population of people who have criminal legal system involvement, right? So when you make decisions about housing people based on their criminal legal history, you are sort of by proxy making decisions based on race, if that makes sense. Hopefully that'll make sense. So that's sort of where all of this kind of comes from. And what do I mean by criminal history information? So it's a really broad term, but that can mean arrests, convictions, sort of other outcomes of criminal court cases, but general information about someone's criminal history, so to speak. Next slide, please. So the first key limitation regarding FEHA compliance is that when you are looking at criminal history information, you can only consider criminal convictions. So criminal convictions essentially where someone, went through a process in court and they were convicted of the crime, right? They were convicted of the crime or crimes they were charged with, found guilty, right? And there's a record of that. You cannot consider other criminal history information such as arrests, any other information that you might glean about a client being taken in for questioning or being involved, being taken into a police station for any other reason, infractions for things like speeding, certain criminal cases that did not result in convictions. So sometimes people are charged with a crime and then they go to criminal court and then the case is ultimately dismissed. Or maybe the judge says, do X, Y, and Z thing, and then it'll be dismissed. So not all court cases end in convictions. So you can't take into account those types of cases. Also, sealed or expunged convictions cannot be considered, and the outcomes of juvenile court proceedings. So for example, if your client was involved in a juvenile case because of shoplifting or something like that, and that all was resolved in juvenile court, that cannot be considered as well. And the reason underlying this policy is that people are subject to arrest and charged with crimes all the time. And especially people of color often are disproportionately arrested and charged with crimes. And we know that based on what we've been talking about. But in our country, they're considered innocent, presumed innocent until conviction, right? So all of those other things don't matter. They should not matter. And even after conviction, our society has said that if people have their records expunged or they're sealed or the case ultimately was dismissed, it's important to let those people move on with their lives. And we shouldn't continue to punish them through these collateral consequences indefinitely, right? So that's sort of the reason why convictions are the only thing that can and should be considered. Next slide, please. So the next limitation is that if you do consider convictions, you can only consider convictions that are directly related to housing, right? So considering, in order to make that determination, right, and it's a little bit squishy because you could make the argument that lots of convictions are or are not directly related to housing, thinking about the nature of the crime, the severity of the crime, right? Was it a particularly violent crime? Was someone injured? Did the crime occur, on private property? Did the crime have to do with property? Was it arson? Was it a breaking and entering, that kind of thing? How long it's been since the crime occurred, right? Someone who was convicted of something in 1983, for example, and hasn't had any conviction since then, that's something to really consider, as opposed to someone who was convicted, 6 months ago. So I think, and also another thing that will impact this analysis, whether something's directly related to housing, is, anything that might have changed since the conviction that can sort of help explain their current circumstances and whether it's changed. And I'll get into that in just a moment. And again, the policy behind all this, again, is that, criminal history information, as Lily said, can only tell us so much. It doesn't tell us how our clients are going to be as tenants. It doesn't tell landlords how our clients are going to be as tenants, especially if the conviction is particularly old or has nothing to do with housing or tenancy. So that's the policy underlying that. Next slide, please. FEHA also prohibits the use of blanket bans for people with certain convictions. So for example, you cannot have a policy that says we don't accept felons, right? Or we don't accept anyone with an assault conviction, right? We just don't. You cannot have those blanket bans, again, because you're making a determination without really understanding the situation. You're denying access to someone to housing without understanding the person's individual circumstances. You don't know really what type of conviction it was, what type of felony. There's so many felonies, right? You don't know how long it's been since the conviction. And you're not giving the person the opportunity to present that mitigating information, right? Saying this happened 15 years ago. I was using substances at the time. Since then, I've completed a drug rehab program. All those things that really help you make an individualized determination about this person, right? Blanket bans completely wipe that out. So those are prohibited. Okay, so the next question. All right, so that was a lot. And we know that, we've been putting a lot of information out there, and we just want to take a moment to see if people have questions before we move on. And also to acknowledge, the reality that you all are responsible, for the safety of your staff. You're responsible for the safety of your clients. And there's a lot of pressure on programs from the community at large to screen people, to do all of that kind of gatekeeping, right? We've been hearing stuff, about different programs having to, relocate people or do different things because of community pressure, saying you can't house this person here. This happens in all communities, unfortunately. But I think, we just want to let you know that we understand that. We understand that you're under a lot of pressure, but we also want you to know that this training and these tools are here to help you make yourself feel confident that you are both ensuring the safety of your staff and your clients to the extent possible, and also helping end homelessness and preventing unlawful discrimination. So doing that individualized, nuanced analysis of who is this person in front of me who I'm assessing, determining whether or not they can enter my program, or if you're working with a landlord, helping them understand that, is really where you're able to make sure that you're both addressing the safety issues that everyone has, right? But also making sure you're not perpetuating the inequities and the disparities that we've been talking about, and helping move the needle towards ending homelessness. So with all that said, we just wanted to put that out there and see if anyone has any questions about anything that we've talked about so far, before we move forward.
Yeah. So if folks can go ahead and use the chat box and let us know where you fall on the 1, 3, and 5. There are 2s and 4s in there too. So 1 would be in the chat box would be, I needed to ask a question now. That was a lot. I want to clarify something, which is totally fine. 3 is, I'm good. We can keep going. And then 5 is like, absolutely full steam ahead. I'm with you. Tell me something I don't know. So I'll give you all a second to chime in on the chat. And thanks. All right.
And don't feel ashamed to say one.
Yeah,
I want to see a one. I like ones. So, put it out there. If you really do feel like you need a pause or you need to have something that you want to share with us or have a comment or question. But also seeing lots of 4s and 5s, which is great too.
All right. So far, it's looking like if anyone has thoughts, they can wait. So we'll assume we're going to move ahead, but really do also want to encourage people. We're going to have time for Q&A. Got a 3. All right. Feel free if you want to track your own questions, that's fine, but you can stick them in the chat box too, and we'll be tracking them to call upon them when we have a little bit of time at the end for Q&A and discussion. All right, well, we will go ahead. If a shy one wants to hop on, let us know. But otherwise, we'll move on into conversation about working with clients on the registry. So before we dive into it, I want to kind of put a couple flags out early on in this conversation. One is just to say that talking about folks on the registry and talking about serving clients on the registry and talking about the crimes that people are convicted of that land them on the registry is a really hard and fraught conversation. I would say that open discrimination against people on the registry is one of the things that the majority of people in this country feel pretty great about. People feel very comfortable as a community, as a society as a whole, discriminating against people who've been convicted of sex offenses. And so I just want to kind of put that out there to start. It brings up a lot of fear. A lot of people have experienced their own trauma. It's a really hard and scary conversation to have as a community and certainly as a service provider, trying to help people on all of these sides, as Viola was just sort of saying, can be really hard. So I just wanted to flag that and to say at the outset that nothing that I'm going to talk about in this next section is to suggest that the harm that can be caused by sexual offenses is not a huge deal. A ton of harm is caused by sexual offenses and by inappropriate sexual behaviors. But for purposes of this conversation and for purposes of talking about how to work with the human beings who are convicted of these crimes, whether they are acts that they actually did commit or things that they've been convicted of unjustly, that requires us to look at the whole human beings behind the crime. So that's going to be the focus today. Before we also dive into it, also just wanted to say that the sort of format that I'm going to take for this next section, we're going to do a little bit of sort of big picture stuff. Many of you may know this already, but some sort of conversation about who is on the registry, why people are on the registry, changes that have happened in California about the registry, because there are so many assumptions that are made in that space. And the purpose of this conversation is one to kind of educate ourselves as a community, and to share. Welcome again to chime in the chat if you have your own personal reflections on the content that we're covering, but to really try to give you tools to have communications with property managers and landlords and staff to help sort of shift how the community thinks about people on the registry and help break down some of the barriers to housing that exist, because a lot of that has to do with stigma and sort of community backlash, even more than those actual laws, which are also a big piece of it. So again, it's the long-term consequences and those collateral consequences, the legally baked in ones, and just the what people do in their everyday interactions. And then we'll move then to talk about some sort of practical things that you should be aware of in the community, you can connect folks to help address specific barriers created by being on the registry. And then we'll kind of summarize at the end some tips and tricks for working with people with all kinds of convictions, and then also 290 convictions. So just a little framing. So first, what do we know about the registry? Well, one is that in California, people who have convictions related to over 100 different crimes may be required to register their whereabouts with local law enforcement periodically. And there's a whole scheme for it having to do with birthdays and things like that, but we won't dive into those particulars today. But the point of this is just to sort of make sure that we're all keeping in mind that there are over 100 different criminalized acts that can land people on the registry. And there is also, with a lot of them, some discretion, judicial discretion, ways things are charged, where someone who has been convicted of the same, two people who've been convicted of the same thing, someone may end up on the registry and someone may not. The California Department of Justice Megan's Law website, which you are probably familiar with, publicly posts many registrants' names, address, conviction history, and appearance. So this again is very, very different from most convictions, right? Even if you've been convicted of a serious crime, homicide or arson, there isn't a database where people can go and just pull up all that information. So in terms of the sort of legally permissible, the laws in place that perpetuate stigma and discrimination, make it easier for people to have that information for various, well-intended or otherwise reasons, it's very different. So just to flag that there's a distinction for people on the registry as opposed to people with other kinds of convictions. People on the registry reflect a full spectrum of economic statuses, racial and ethnic demographics, sexual orientation, gender identities, and we're convicted again of this wide range of different criminalized acts. So I've captured just a few, examples of convictions that frequently require registration. Can be things like public nakedness, so things like streaking, even selling sculptures or paintings that depict naked children or child pornography, sexting, which is, we'll talk about it more in a second, a huge issue, particularly for youth who have to become registrants, rape, things that seem very obvious, like, yes, you're on the registry then, urination in public, child trafficking. So I put these up there just to sort of, again, remind us collectively that there's this huge range. Like most people look at sexting between teens, for example, and child trafficking very differently. And yet the same collateral consequences may be attaching for people. And then again, on top of that, all of the background, all the context and the demographics and who is prosecuted. The truth is, as you know, that the majority of people who cause sexual harm are never arrested and are never prosecuted. And the majority of sexual abuses that occur happen inside of homes or interfamiliar or people who are known to each other. So there are assumptions, I think, for a lot of sort of your general public that, the people on the registry are, are people hiding in bushes and jumping out and attacking strangers and abducting children. And when the truth is the vast majority of people on the registry, the vast majority of people who commit these kinds of harmful acts are not on the registry and are unknown. And then the majority of the people who are on the registry are not actually on there for those kinds of acts at all. So just, again, sort of broadening how we think about who is impacted by the registry. The last couple points, being on the registry significantly restricts certain freedoms otherwise available to non-registrants. So it may be a bit of a no-brainer, but again, calling up the very obvious example of the restrictions on public housing authority admission for people who are lifetime registrants. So those are some things that we do know about the registry. So I'm going to move now into a little bit of myth busting. So a few facts about the registry and then a few assumptions about the registry and unpacking those. So we'll start with the facts. Next slide, please. So fact one, this is a little history nerding out session. California's registry was one of the first ones in the country. I think it was the first one in the country. It was created in the 1940s. And prior to this year, California was one of just 4 states in the country with a lifetime registration. So the other states were South Carolina, Alabama, and Florida. And that was just changed this year. And we'll talk more about that in a little bit. But because the registry was created in the 1940s, the laws that created it and the code that was written to sort of govern what crimes were going to be eligible for the registry reflected a lot of the biases and discriminatory views that are still very much alive and well, but were even more so widely adopted in the 1940s. So specifically, a lot of eligible convictions had to do with same-sex sexual conduct. So completely consensual, but things like sodomy laws, which exist in California until this last year when SB 145 repealed it, meant that there are people who are on the registry who were, for example, convicted of having consensual sex with someone of the same sex in 1990 something or 1960 something, and they've been on the registry for that ever since and have endured all of the collateral consequences associated with that, having their information posted on Megan's Law, having to report, having all the barriers to housing, etc. So this law that was passed recently has re-examined some of those discriminatory laws, and so we'll be addressing a lot of the disproportionate impact that LGBTQI+ people in particular have experienced because of when and how the registry was created in California. So the second fact, in 2017, California spent $140 million a year to register youth, to put youth on the registry, yet designated only $46,000 for victim services and prevention related to registry-related crime. So this is really just to kind of share some information and paint that picture about where resources are and how we address harm through our criminal legal system. Certainly many of the youth on the registry were convicted of, and presumably many of them did commit very, very serious harmful acts. But a lot of them are also, you hear about Romeo and Juliet laws, which that's not insignificant, which is a reference to things like, an 18-year-old girl having a 16-year-old boyfriend and the parent objects or someone finds out, and people can be put on the registry. People can be put on the registry for streaking or urinating in public or all kinds of things that many people do, but particularly teenagers whose frontal lobes are still very squishy do. And then that also, not every youth who urinates in public and is caught ends up on the registry. But so those who do, that brings in questions about access and resources and race and all kinds of other systemic issues that really shape who is arrested, who is prosecuted, what they're prosecuted for, and what judges and prosecutors, what those decisions end up looking like, who has access to legal representation, who has access to substance use treatment, and all those kinds of things can all play a role in that. And the third fact, California's new tiering law, which we'll talk about in just a second, having to do with people having access to having their lifetime registration requirement reclassified into a 20-year or a 10-year, or being removed at this point from the registry, is not automatic. So for some people, I think people thought that law passed and therefore it would be taken care of. And even though 90% of people on the registry are eligible. I see you, Gemma. Yes. Thank you for sharing that thought. So even though 90% of people who are on the registry are eligible for at least application for retiering, that will not happen automatically. And so it's really important from your vantage point, looking at these barriers, trying to connect people to resources that may have huge, huge impacts on their ability to access housing with these kinds of convictions, to be familiar with the processes to do that and to try to help support clients to the best of your ability, realizing you already wear 57 hats, you can't wear 82 hats, but how to try to locate those services in the community so people can address those barriers because it's not automatic. Okay, next slide, please. So moving on to some assumptions. So the first assumption is that sex offender registries prevent reoffending. So the data has shown absolutely that is not the case, and it's not the case for multiple reasons. One is that, as I mentioned before, the majority of sexual harm that is caused is not ever caught or prosecuted or reported even. And the registry, the recidivism rate for people on the registry is incredibly low. And it's for this reason, actually, that a lot of I think it was the DA's Association, that like all kinds of law enforcement people you'd be surprised about actually came out in support of SB 145 that I mentioned before, is because the number of people on the registry actually pulls resources and attention away from the sort of high risk people who probably need the most support and monitoring in the community. When it has to be spread out across a whole bunch of people who don't need that kind of support, who are very low risk of offending ever again, or the offense was not like an egregious kind of offense that people are particularly needing to like spend lots of time and resources managing. So that's really important. It ties into the piece of making assumptions about like who is on the registry and why they're there. And I just sort of spoiled my second one, but the registries are necessary to help law enforcement and the public track people who present the greatest risk to the community. I just kind of explained both of those at the same time. But again, if anything, there's a lot of significant concern, and the data supports that actually more resources are used and therefore are less able to be targeted meaningfully for people who have really serious treatment needs, need to have a lot of support and a lot of monitoring to be able to, recalibrate and come up with other behavior patterns, as opposed to a person who's on there, for example, for, having consensual sex. A man who had consensual sex with another man in 1995 probably doesn't need to be sucking up those resources. And then the third assumption is that restricting housing options for people on the registry improves public safety. Certainly tied in to the points I was just making, but another piece is, and this is something that is, again, one of those hard pills to swallow, but there's just some reality about the housing restriction piece that doesn't even really scratch the itch that a lot of people are trying to, which is to say that if someone is restricted from, for example, living within proximity to children, that is just where their house is. It doesn't restrict where they go. It doesn't restrict a ton of things. And I'm not saying that it should, but there are these sort of assumptions, and there's a real fear that people are hoping to sort of quench. I think I made up a word, squelch, one of those, by having these restrictions put in place when they're not actually grounded in public safety data or information or about what people really need. So there can be a huge outcry about someone being proximate when, for example, proximate to children is a huge piece, when, for example, the person's conviction had nothing to do with a child. And it was 25 years ago. And they work within 2 feet of a daycare center, but they can't live anywhere. And so they have a really hard time getting to work. So it becomes this question of sort of what is true public safety and what are we actually trying to address, and how are these laws actually reflective of the fear that we have that we're trying to address versus how are they sort of, as being indicated in the system, how are they actually intended to, or generously producing unintended consequences that are just continuing to oppress particularly certain groups of people. All right, so big picture stuff. Now a little more nitty gritty stuff. So this is just to remind, the FIHA stuff that Bila just went over applies to all criminal history information, regardless of the nature of the alleged crime, including people on the registry. So that means that any housing decision based on someone's requirement to appear on the 290 registry must still meet the FIHA requirements, right? So you still have to show, as I was saying, there has to be an opportunity to respond, to show mitigating information, and it has to be directly related to housing. So it is often the case that having someone be, if an agency was sued for discriminating against someone based on their conviction, again, because public sentiment still supports discriminating against people on the registry, public sentiment is pretty, supportive of that. You may be able to do it. Whether you should do it from an equity standpoint, from a housing standpoint, from what we know about public safety and true safety and all of those standpoints, different topic. But it also, that California law is in tension in some ways with HUD guidance. So I have the quotation here. I know a lot of communities we work in, agencies rely on this, but it's from the Fair Housing and Equal Opportunity COC provision in the interim rule. So it's section 578.93 or something like that. It's in the reference slide if you need it. But it says that if housing has in residence at least one family with a child under the age of 18, the housing may, permissive, doesn't require it, it may exclude registered sex offenders and persons with criminal record that include a violent crime from the project, so long as the child resides in the housing. And I'll just flag this. One, this is in tension with FIHA. So again, this is not legal advice. I encourage you to bring it up with county council or to reach out to HSA for more guidance on how to figure these pieces out. But those are in tension, right? If it says you may do that, it's federal law, which usually trumps state law, but it's permissive. It gets a little legally hairy. But I will say that there's some tension there. And I do want to just highlight that HUD has since put forth guidance that very much is in the line with this piece, right? Where they talk about things that are much more fair housing oriented, right? Because as we were just talking, one family with a child under the age of 16, someone who's on the sex offense registry for public urination when they were 16, what's the concern there? What's the nexus to housing? What's the risk that people are trying to meet? And what would the legitimate reason for discriminating that person be when they're 37 years old, et cetera? And also with a criminal record that includes a violent crime, their drug sales can be considered violent crimes. It doesn't define violent crime. It's a bit of a mess, if I may say so. So I just want to encourage everyone, if this is language that you have created policies and procedures around, would really encourage you to revisit this, to have this conversation agency-wide, community-wide, and make sure that you're not only aligning yourselves with California law and requirements, but you're also challenging your organization to look at the logic and the opportunities given to people who are having these kinds of policies applied to them. Next slide, please. All right, we'll not get too nitty gritty about this, not to mention enhancements. Yes, it's a whole other training. Current registry considerations. So by this, but if you didn't know at this point through all the references, you now know that there has been in 2020, a law was passed in California that makes people eligible to have their lifetime registration re-examined. So there's a tier-based registration scheme in California now. So people who are tier 1, still 10 years on the registry, which again, for things like, public urination or, taking your clothes off in your car when you're high, which happened to a former client of mine. It's been on the registry for decades. So people must register for minimum 10 years. There's tier 2, which is 20 years, which is a mid-level offense. And then tier 3 is a lifetime registration. And those people are not allowed to register for petition for removal. And there's a whole separate retiering scheme for people who have registry-related convictions as juveniles. So just wanted to share that there. Again, I know that we talked already about how this is not automatic, but there are, again, 90% of people on California's registry are eligible for retiering. And particularly when you look at things like, yes, there's a copy of this info, we'll share slides out for sure. And it's got references so you can look stuff up as well. Particularly for people who, like for public housing, which has a ban against lifetime registrants. If you are a 20-year registrant, you are no longer a lifetime registrant. So this opens up a ton of doors for a lot of people in a lot of ways. So really, if you're working with people who they themselves are on the registry or they have family members on the registry and it's impacting everybody's stability, employment stability, housing stability, it's really worth looking into this. And we'll share information in just a second, or probably just a minute, about places you can go for support so you don't have to put on a 850th hat and be doing your clients' retiering applications. All right, considerations and tips.
Okay, so I'm going to move pretty quickly so that we have time for questions, but we just wanted to provide some information about what you can do to help address barriers and sort of increase housing access for your clients who've been impacted by the criminal legal system. Next slide, please. So just to recap, the first thing you want to make sure is that you understand the nature of your client's background, right? As we've been discussing, you want to know the type of convictions, including the nature of the offense, how long ago it was. You're going to want to know the circumstances surrounding the convictions. Were they a survivor of domestic violence at the time? Were they having a mental health episode? Were they under the influence of substances? And also, if anything has happened since their conviction that might help them sort of overcome the barrier that they're facing. So can you say they've been pursuing their education, or they've been involved in the community, or have been engaging in services that addressed the issues underlying the conviction? Basically, all of this information will help you understand what mitigating documentation you can help your client with so that they can say to landlords, hey, this is sort of what happened, and this is why I don't pose a threat, why you should put me in your apartment and agree to house me. Next slide, please. So you're also going to want to understand the restrictions, which is why you're here today. It's great. Now you understand the restrictions. No blanket bans. You can only consider convictions. They have to be directly related to housing. Next slide, please. One other thing that is really going to be helpful is if you rethink document readiness. So a lot of times people think I have to figure out, whether the clients get their income documentation and get documentation on their credit or whatever the situation may be, things that are very clearly directly related to housing. But it can be helpful to try to broaden your perspective on document readiness by thinking about what other documents should I get to help my client overcome their particular criminal legal system related barriers. So again, that mitigation documentation that explains the conviction and why they don't pose a threat to anyone. Some of this can be done before someone's even released. If you try to work with them early through a jail in-reach program, for example, You can also try to talk to your client's criminal defense attorney with their permission, right? You always want to ask your client before you talk to other people about them, so that that attorney can maybe help you understand the criminal conviction a little bit. If you're just looking at your client's rap sheet, for example, it may be inaccurate. So it's helpful to speak to the attorney directly to find out like what the criminal conviction actually says. And maybe they can also help you think about other types of mitigating documentation you can get. Next slide. So obviously you're going to want to come up with a specific plan with your client to identify what barriers they might be facing and how to address them. You want to make sure that you understand what the range of housing resources and programs are in your community that can be helpful for them. We'll talk about a couple of those in just a second. But another thing is sort of learning and getting practice in how do you help your client reframe their story. And I know a lot of people have experience in doing this already, but helping them tell their story to landlords and property managers, not hiding information about their criminal convictions, right? Not lying about anything, but basically highlighting their strengths, right? What does this person have to offer? What, why would they make a good tenant? So sort of figuring out how to reframe your client's, your story for that purpose. And the next one is just, being your client's advocate and being an educator, right? Educate landlords about FIHA and underlying equity issues. Work with community partners, including the San Mateo Private Defender can assist with record clearance issues. Their information's on there. Community Legal Services in East Palo Alto has a free live scan event the third Thursday of every month to help people with rap sheets. So really leveraging the resources in your community, and also just looking within to try to identify what are some of your own personal biases that might be leading to, furthering discrimination against people with criminal legal system involvement, and maybe thinking about what are some of your agency's practices that could be limiting access to housing intentionally or unintentionally. All right, gonna pass it back off to Lily to take us home.
Taking on home. Okay, a few slides just on the folks on the registry as well. So just a reminder to make sure that you're checking the registry and the website and requesting letters to confirm the accuracy of, and this is particularly a lot of folks on the registry should have gotten retiering letters. Maybe they got them, maybe they didn't have an address, maybe they didn't get them. So those letters exist, and you should help connect your clients to someone who can help them request them, and then confirm them, make sure that they are accurate, because certainly errors can be made, and it would be really a shame to think that you weren't eligible to get off the registry and you are. A really important place to think about in connections are in landlord engagement, outreach, and incentives. There certainly are landlords, property managers, folks who are open and willing to renting to the people on the registry. And it's important to, like in any of your efforts in that space, make compelling and make it easy for landlords to say yes, hopefully using some of the information that you already know and the stuff we've talked about today to help landlords and property managers be familiar with the assumptions versus the facts, and certainly incentives never hurt. Leveraging community, there's a link there for Friends Outside, which is an organization based in LA. They have a toolkit that includes a section for people on the registry that has a list of supportive organizations and groups, as well as people who work with people on the registry. I encourage you to take a look at it. But particularly for people on the registry, isolation and stigma is massive. And if you're living on the outskirts of town, if you can find housing and you're supposed to be getting to treatment, it's hard to get to church, it's hard to get to other sort of positive community spaces. So really good to look into those kinds of resources. And this last bullet point is for people who are not on the registry, who are working with people on the registry. So do not encourage clients who are registrants to access the Megan's Law website. That can get them in serious trouble, but you can. And one of the tips that we've received over time talking about this topic is that if you are wondering where property managers and landlords may be open to housing people on the registry, one way to do it is to look and see where people on the registry are living. So that's more for providers if they are looking for landlords to reach out to, those kinds of things, that can be a resource. Next slide, please. Oops. think I have the same thing twice. So it's still true that you should check for the accuracy of information, help clients request hearing information, and then help eligible clients connect to paths to terminate registration or to be retiered. The same information that Viola shared before is relevant here. There's the San Mateo Private Defender through the Bar Association that can connect people to private defenders who can help with that. And there's an email for them as well there. And then Community Legal Services of East Palo Alto does do expungement work, record clearance work, retiering work. They're limited capacity wise, but they really do, they welcome calls and they will try to help assist your client or connect them to someone else who can. And then to make sure that post-housing denial advocacy happens. So if a public housing authority denies somebody housing because they have a sex offense, they're on the registry, but they're no longer lifetime registrants, that public housing authority doesn't know that there's been a shift in the law. And so that's the kind of thing where I think a lot of people on the registry and people with criminal convictions can become complacent with discrimination because they're so accustomed to it and it is so sanctioned in our society. So making sure that people know when, that you have their back and that people are connecting to fair housing advocates, folks like that, if you can't take on that role, to make sure that people are helping educate about inappropriate discrimination for people on the registry and just with criminal conviction histories. And with that, this is our girthy reference slide to look this up. And on the next slide, we have, please feel free to reach out for questions, follow-up questions. That's the criminal legal system at Homebase's email and the San Mateo team's email. Viola and I happen to be on both. Joy, our colleague who's joined us today, is on the San Mateo team as well. It's the San Mateo Private Defender, which is confusing. There is no public defender in San Mateo, but they have a bar. San Mateo Bar Association runs a panel. So it functions kind of like a public defender, whereas people can access private defender services as though they are a public defender, but there isn't a public defender's office. Very odd. Not totally unusual, but if you're familiar with public defenders, it can be a little off-putting. So with that, we just have a few minutes. Please feel free to ask questions, concerns, clarifications, things that sounded right or wrong to you. We welcome that. Yes, Gemma. So in other counties, yes, if there's a public defender's office, yes, go there or to community legal service organizations. And either way, if you reach out to them and they don't do that, they aren't helping with that, they can direct you to who is. But all public defender's offices should be doing that.
And is it free?
The public is what part?
Getting your record expunged.
Yeah, if you go through the public defender or the community legal services, there can be fees associated with certain kinds of applications, but typically I can't speak for all of the agencies across California. Typically, if it's through community legal services or the public defender, people who cannot afford to pay those, there will be a way to waive those, and you can apply for those waivers. So it probably, the direct answer is it depends, but yes, typically that should not be a prohibition on someone's ability to pursue that. But you do need to get linked up with one of those agencies, one of those organizations to help. Does that answer your question? Yeah, of course.
Oh, a question too. So just to get this right, the private defenders is in place because there isn't a public defender, but is a private defender still costly or is it seen? Okay.
So it's, I hope I'm getting this right. I think I'm getting this right. So in counties, and if anyone knows otherwise, let me know. In counties where there isn't a public defender's office, often what happens is the Bar Association for the county has a panel of attorneys that they appoint cases to as though they're public defenders. But there isn't a public defender, like the public defender of the county, and there isn't an office where they all work. So there can be things that are complicated about that. You don't have the same resources or sort of that office, but there still is that service available for people who need appointed counsel in that way. That's my understanding, at least, I should say.
Oh, we have a raised hand, Miguel. You're not able to unmute yourself.
Oh no.
Can you hear me?
Yes.
Can you hear me?
Yes.
All right. Quick question. So right now it's not too big of a deal because with the pandemic, we've gone to a lot of doing assessments over the phone with our clients here at the Fair Oaks Community Center. But one of our biggest roles is referring clients to shelter. One of the barriers we've had in the past with P290s has been because we have a child care facility on site. And some of the information that you've given us or given today, it opens up my eyes to a lot of things, but also some stuff that I've thought in the back of my head. But individuals like, let's say you said, they're on the P290 because of your public urination or streaking or stuff like that. Are those individuals as well not allowed to be near child care facilities?
So let me see. So I have to flag again, I can't provide legal advice. So I really encourage you to check in with the high up folks, have those conversations as an agency, and encourage you to reach out to HSA or to county council. But like the information we shared suggests, FEHA would say you can't have a blanket ban unless it's public housing, unless it's a public housing authority. And then even there's tension. That it has to be an individualized assessment. But there is, like I shared in that slide, there's some tension with HUD guidance in the past about, if there is, at least one family with a child under 18. So there's some tension there. And I think, I don't think it's a good idea for me to provide legal advice in that specific situation, but you are picking up on a place of real conflict. And I think before this California law was passed, which, happened during 2020, people were busy during 2020. So I don't think that a lot of people have had a chance to reflect a lot on the new additions to FEHA, but there are a lot of folks who aren't currently FEHA compliant. And again, yes, exactly. Good point. Thank you, Viola. There may also be restrictions based on community supervision requirements. So if someone is on parole or probation, and because of that, they cannot be proximate to kids, that is separate. But in terms of your agency's policies and procedures, if someone has a conviction, they've been off parole for however many years, but they are a registrant, that calls up a different issue. So again, it's sticky. There are a lot of places where it's like, well, if it's this, then it could be this. But we would really, really encourage you to talk to county council and to look at your agency's policies and procedures around that. And definitely, if home base, we do technical assistance on this topic and help people think through these things. So I'm happy to talk more about that as well.
Okay, thank you.
Sure. All right. Well, I know we're at time. Thank you everyone for coming and for sticking around for a few extra minutes. I'll lurk around if anyone has any other questions that you want to raise now. Happy to answer them. Otherwise, please do take a couple minutes to fill out that survey. And thanks very much for being here. It's a big topic, so we blazed through a lot of it and are always happy to do that here with you all in San Mateo. So thanks again for your time.
Thank you so much.
Interesting.